Good afternoon, everyone. And again, thanks to Era and Karine for the invitation. Well, my first and actually quite challenging objective would be to try to keep your attention during this last intervention of the day, and a day which has already been rich in information and reflection. So I have the privilege to talk to you about reception standards and rights in Europe. And Minas will also raise more specifically the issue of increasingly thin boundaries between reception and detention, drawing from practice in the hotspots as well as elsewhere. So, here you will see the overview of my presentation, and massive arrivals of asylum seekers in 2015 have pushed reception systems of several EU member states into severe crisis, near collapse or complete collapse. And this crisis was, and to a very large extent remains until today, first and foremost a crisis affecting reception capacities across the EU. The number of arrivals has maybe decreased in 2016, but the pressure on reception systems remained very high, given in particular the large number of applications which are still pending until today. So the focus of policymakers of the EU went to issues of relocation, hotspots, and processing of asylum, but probably less to the question of determining how the reception standards were actually met. And that raises serious concern, since effective access to adequate and decent, dignified reception conditions forms undoubtedly a prerequisite for any fair, decent, and efficient asylum procedure. So I propose to start with tackling the fundamental aspect of reception. This is to say its role in safeguarding the most basic human dignity of those seeking protection in Europe, because that's what we are talking about when we talk about reception. And then, in order afterwards to continue with assessing the response given by the Commission with the recent proposal for the revision of the Reception Conditions Directive. In order, finally, to give you the point of view of a reception agency on the implementation of this directive. So I will start with reminding you that reception goes about human dignity. From the beginning of the CS, adoptions of standards for reception conditions has always been seen as a key issue in order to create a common space of protection. And then it was one of the primary state aims of the EU action in this field, leading to the adoption of the first directive in 2003. The directive makes an explicit reference to Article 1 of the Charter of Fundamental Rights, when saying that this directive seeks to ensure full respect for human dignity and to promote the application of Article 1 and Article 18 of the Charter. Let's also notice that it is the first right under the Charter, and also that dignity is also a fundamental, a foundational value of the EU. And the first one also, since Article 2 of the Treaty on the Functioning of the European Union states that the Union is founded on the values of respect for human dignity, and then freedom, etc. therefore, we find in this directive this concept of human dignity in different articles and in the recital. For instance, here in the slide you can see the recital 11 says that there is a need to ensure standards for the reception of applicants that will suffice to ensure them a dignified standard of living and comparable living conditions. And also that harmonizing reception conditions in order to ensure equal treatment of applicants throughout the Union is paramount. This said, I will review the case law of interesting cases of the Court of Strasbourg, of the Court of Luxembourg, and also of national courts. And this talk about the Saccheri judgment from 2014 from the Court of Justice, because the court had the opportunity to interpret the relevant provisions of the directive. It was the directive of 2003, but it's perfectly transposable to the one of 2013. And these provisions are those defining the general rules on material reception conditions, the rules that say what is reception. And the case, and I will come back on what triggered that case, because it concerns Belgium. And it relates to a severe crisis that occurred in Belgium during 3 years, between 2009 and 2012, which affected around 10,000 asylum seekers that could not be accommodated due to the lack of places. And the question that was asked by the Court of Appeal of Brussels concerned the level of financial assistance that a member state must make available in case they are granted financial rather than in-kind assistance. And what the court said is that if reception is given through financial allowance, the member state must ensure that the total amount of the financial allowance covering the material reception conditions is sufficient to ensure dignified standard of living and adequate for the health of applicants and capable of ensuring their subsistence. What was the problem in Belgium? FEDASIL, my agency, we didn't have enough places to accommodate everyone. So what we did is that we took decisions. I mean, that was hundreds of decisions every day given to the people, telling them, look, we don't have places, but you can go to the local social welfare center where you can ask for a financial allowance. This is actually, we were referring them to the general public assistance system. And the courts, the tribunals, actually in Belgium it's the labor tribunals, condemned the agency almost hundreds of times during 3 years, saying that it was perfectly illegal because the Belgian law gave to the agency, and to the agency only, the competence to provide reception conditions. And that there was no reason for shifting the burden to the general welfare system. The Saccheri case helped us very much to defend the legality of our decisions, because the court said in the same judgment that, especially where the accommodation facilities are overloaded, that member states can refer the asylum seekers to bodies within the general public assistance system. So here it's a good example of a judgment of the Court of Justice that really changed the practice in Belgium. It changed the case law of the tribunals in Belgium, because after that our decisions were considered as legal. And more importantly, and that's also what I would like to stress, it's that the court here emphasized on the link existing between the procurement of reception conditions to asylum seekers and the procurement of social aid under the general public assistance system. which is finally absolutely logical, since both systems follow the same objective, ensuring a life in compliance with human dignity. So there is no difference at the end of the day between reception conditions for asylum seekers and general social aid that is given to all citizens, because it guarantees the same fundamental rights. Then the Strasbourg Court. The Strasbourg Court also tackled this issue of human dignity. Here I took a case, and it's really a coincidence concerning, again, Belgium. Because it's the most recent one. It was from last year. It's the case of VM and others against Belgium. And here it was about a situation of a family of people who were Dublinized people, so people under Dublin, and they have been considered as having been unduly deprived of reception conditions for a period of a month. And then what the court said, repeating its jurisprudence of famous cases like MSS and Terrakel, that the failure to provide dignified standard of living to asylum seekers can amount to a violation of Article 3 of the Convention. Just want to simply draw your attention that this case has been referred to the Grand Chamber, and that the hearing took place last May, so it's not a final judgment for the moment. Another example of case law, and here it goes over a judgment of the German Federal Constitutional Court, which is also quite interesting here, because actually what the court did, the court declared the Asylum Seekers Benefit Act as unconstitutional in July 2012. Why? Because the benefits paid out in cash were incompatible with the fundamental right to a minimum existence. Indeed, the level of social benefits under the Act was about 33% lower than regular social welfare benefits. And so here, what the court is said that the basic law, the Grundgesetz, establishes the right to the guarantee of a dignified minimum existence as a human right. German and foreign nationals alike who have their residence in the Federal Republic of Germany are entitled to it. Adequate benefits have to be ascertained in light of the circumstances in Germany. So that the necessities of a dignified life in Germany cannot be assessed at a lower level by referring to the existence level in the country of origin of the person. So, with this different case law, we can come to the conclusion that this concept of human dignity, of ensuring a dignified standard of living that we find in the directive, must be applied without, that there is no discrimination or difference to make between asylum seekers and nationals when it comes to ensuring the respect of human dignity. So now I will come, having set the scene regarding which fundamental right we are talking about, we are going to come to the Commission's revision proposal of 2016. Alors, this revision, the Commission presents the need for such a revision by stating three main objectives. First, further harmonizations of reception conditions. All applicants should receive an equal and dignified reception standards in the EU. That's what the directive of 2003 and 2013 already stated. Then, ensuring an orderly management of migration flows and provide member states with efficient tools for fighting abuse and secondary movements. And then, finally, increase applicants' self-reliance and possible integration prospects. That's the stated objectives of the Commission. So I will here highlight some of the modifications proposed. The first one is that in the Directive of 2013, we already find the concept of an adequate standard of living and a dignified standard of living. And I have to say that in the Directive of 2013, I never really saw which was really the difference when it comes to practice. But now with the proposal, it's a bit clearer. The adequate standard of living, you see the definition, is applicable to all asylum seekers falling under the scope of the directive. That's what the reception conditions, whether material, financial, or a mix of them, must guarantee. Then, and this is new, this is the definition of what is a dignified standard of living, because apparently there is a difference between what is adequate or dignified. And here, you can read, you can see that by dignified standard of living, we talk about providing subsistence and basic needs, both in terms of physical safety and dignity and in terms of interpersonal relationships. In fact, this concept is defined after having stated that an applicant's entitlement to material reception conditions may be curtailed in certain circumstances, such as where an applicant has absconded to another member state than the member state where he is required to be present. I will come back on this later, but you will see that this definition of a dignified standard of living has been developed in relation with the modifications linked with the new proposals for the Dublin regulation. What we can conclude on that when the expression dignified standard of living is used by the Commission in its proposal, it means that it is a sort of non-derogable minimum standards that has to be guaranteed even when material reception conditions are reduced or withdrawn. So it becomes, when you read the new proposal, that the main reason for proposing it was driven by the need to put it in accordance with the Dublin's revision proposal. I would say that the other two objectives are probably more, how to say that, a pretext, I would say, because further harmonization of reception conditions who is going to stand against that? Of course, it is a desirable objective. I mean, that's why the directives are there since 2003. And then, enhancing self-reliance of asylum seekers, integration measures is of course something which is very difficult to critique. So, here we see the introductions, and that's also something very new, of tools aiming at deterring secondary movements as well as fostering the respect of applicants' obligations under Dublin. For instance, the possibility to assign a specific place of residence, having reporting obligation when exists a risk of absconding, or creating a new additional detention ground. And this new additional detention ground is when an applicant has been assigned to a specific place of residence but do not comply with this obligation, he can be detained in order to ensure the fulfillment of the obligation to reside in a specific place. So if you don't respect an obligation to reside in a specific place, then you can be detained in order to make sure that you will stay in a specific place. That's a quite tautological definition. Since once you are detained, it's for sure that the obligation to reside in a specific place shall be fulfilled. What can be, what is important, because this is for the first time, I mean, that would be the third version, we will see, of the directive, but for the first time, reception conditions are instrumentalized in order to try to secure the functioning of the Dublin system. And this is really new. I have already witnessed that in national law, but not at the EU level. Then there is also a new definition of absconding in the reception, in the proposal. And so what is absconding is the action by which an applicant, in order to avoid asylum procedures, either leaves the territory where he or she is obliged to be present in accordance with the Dublin regulation. And then just after this article, we find also, it's not on the slide, but the risk of absconding. And the risk of absconding means the existence of reasons which are based on objective criteria defined by national law to believe that an applicant may abscond. Well, this definition raises different problems, and I'm sure that Minos will develop on this, but we can already see that the message is very clear. An applicant, in order to receive full reception conditions, and therefore adequate reception conditions, must be where he is supposed to be under the Dublin regulation. We can also note with this definition that when an applicant moves to another member state than the one of the first entry, it's in general not in order to avoid asylum procedures, but well with the aim to lodge such a procedure. So here, in the definition, talk about asylum procedures, but in fact, it's the Dublin procedure that is here targeted. In accordance with these developments, new grounds for reducing or withdrawing reception conditions are introduced. So member states could reduce reception conditions when the application was not done in the member state of first irregular entry or legal entry, or when the applicant has been sent back after having absconded to another member state, or also when he fails to attend compulsory integration measures. That is something apart from Dublin, but this is also something new. So here we see the introduction of what can only be called sanctions, because they are of punitive nature, mainly for having not complied with the rules of the game. And that raises a series of legal and practical problems, and I will turn back to this in a moment. Then, there is a positive clarification also. The proposal states that accommodation, food, clothing, and other non-food items may not be reduced or withdrawn. Only daily allowances may. And it also states that financial allowances may be replaced with material reception conditions provided in kind. And that's also a kind of sanction. And that for me was quite surprising. Why? Because reception conditions are mostly provided in kind across the member states. And so what would be the relevance of such provision? So the aim of such sanctions to replace finance allowances by in-kind conditions, for me, the basic problem is that it gives the impression that finally giving financial allowances is more favorable than giving material conditions in kind, which is absolutely not verified. And also one should bear in mind that providing material reception conditions is in general more expensive than giving financial allowance. Therefore, what would be the interest of member states to make use of such possibility? Where is the incentive to comply with Dublin rules here? Then there are also some articles about, and this is good, that provide for that equal treatment with nationals must be guaranteed for different on different issues, notably the branches of social security, with some the possibility to exclude some kind of benefits. And here it goes with the objective to foster applicants' self-reliance, which is, of course, important. Then, what concerns also the harmonization of reception standards? The Commission is very clear. The fact that the member states fail until today to implement existing standards, not all member states, but just that the fact that this harmonization actually does not really exist. And the Commission states that these discrepancies have contributed to a disproportionate burden falling on a few member states. I think we know which ones, with generally high reception standards, which are then under pressure to reduce their standards. So it is, there is no, from the Commission is right there, they are realistic. It's clear that reception standards are far to be harmonized today across Europe. I just comment over the fact that these discrepancies, these divergences in reception conditions, are they really a powerful incentive to move to countries offering higher standards? Because that's the way it is put by the Commission. Personally, I have some doubts that the lack of reception conditions is really a key factor explaining secondary movements from countries of first entry, like Greece and Italy, to other countries like Germany or Sweden. It can be one element, but among many others. Then finally, I would like to mention that if you are interested in comparing the different reception systems, there are two studies, one by the European Migration Network in 2014 and one more recent in 2016 done by ECRE. They contain very valuable information. But what is important is we can see that reliable data are really difficult to collect, as Minos already mentioned before, due to a kind of lack of transparency and also the different kind of institutional structure in member states between very centralized models or very decentralized models. So it's quite difficult to conduct a comparative analysis of all reception conditions provided today in Europe. That's simply a fact. Then, very quickly, what are the solutions proposed by the Commission to further harmonize the reception conditions? The main tools is guidance and monitoring, with a very important role given to EASO and also the future European agency. With obligations, member states shall take into account EASO operational standards and indicators. Member states shall put in place guidance, monitoring, control of the level of reception conditions, and also this is very important, member states shall draw up contingency plan in case of disproportionate number of applicants. It is interesting to note that member states expressed this progress report of, for October, lots of concerns about these obligations. That is the main concerns expressed to date on the proposal of the Commission. What should be the scope of the monitoring mechanism? What should be the role of the member state in this mechanism? Did you think about the additional administrative burden that such procedure shall provoke? And what will be the role of the agency? This role seems too broad, the obligation seems too excessive, and that shows simply that I think that several member states are very reluctant to have an EU agency that will scrutinize the functioning of the reception system. However, such tools appear quite convincing also, since the underlying idea is promoting, I wouldn't say that it's to promote harmonization, because full harmonization will never take place, but convergence on the different reception systems. So now I will jump to a much more practical point of views. It is about how, I wanted to underline how your reception agency like FEDASIL in Belgium coped with the crisis of last year. Just want to stress the fact that it's far to be easy to react to such a situation, and that different elements are needed to make it to succeed in this respect. Just to give you a quick idea, here I have put a figure. This is the occupancy rate of reception facilities in Belgium between January 2014 and August 2016. So you see, but like in other countries, that from June 2015, there was really a sudden increase with an occupancy rate around 75%, like in 2 months' time. It raises up to 100%. 100%, it means that it's saturated, that we don't have places anymore. What this figure does not show is that we were able to maintain the occupancy rate under 100% because we doubled the number of places. There was a reception network of 16,000 places in June 2016. It was almost 40,000 at the end of 2016. We had contingency plans. They lasted for a month. We had 2,000 places, buffer places. It lasted for a month, so it was absolutely not enough. What do we do to find places? In order to keep the situation under control, of course. First, I think in most countries it happened like that, we turned ourselves to the Defense Ministry, military facilities. Besides the extension of the existing capacities, with putting tents, containers in the existing centers. Then it's not enough. Then we need to identify other places, and very quickly, because it's really a race, a daily race against time. Then it was really a work of identification of all kinds of buildings that could be quickly used, and we end up in October like to rent camping sites. That's what happened a year ago. Today, in June 2016, the decision was made to close down 10,000 places because the number of arrivals dropped dramatically. I mean, it came back to a level of 2008. So it's just to illustrate that reception agency is like an accordion. It has to expand, then to reduce all the time, and to be able to cope with such situations. And that at the operational level, that our plans must be, are somehow always at a, it's like a permanent crisis. We need to cope with the day-to-day situation. So we need to be a bit quick here on this, because I want to come back to another topic. But what I call here on the slide, this challenge of flexibility is very important, and what I call the temptation of the 3 Bs. The 3 Bs stand for bad, bed, bread. It means that it's very tempting to lower the reception conditions, and we have to do it. And the reception, the directive allows it for a limited period of time, at least. The problem is that when the pressure goes away, is to uphold again the standards. That's a problem that we are facing today. And there is also the fear of the air intake, and that's more for at the political level, grounded or not. But then the policy is also driven by the fact, okay, we need to give the 3 Bs, but it shouldn't be too bad, but it shouldn't be too good either. In the sense that if it's too good, maybe then that more people will come to our country. So I will just, public finances and public perception and acceptation are absolutely not a detail, because I would like also to underline that reception is the most expensive aspect of an asylum procedure. Just to give you an idea, to accommodate around 20,000 applicants per year, the budget of FedAsile in Belgium amounts to 350 million. So it costs a lot, and it was doubled last year. So it costs a lot, and in times of budgetary austerity, it's really not easy also to get public support in this field. Okay, so very quickly, because there is one case I need to talk about, is the case Simad and Gisti of the Court of Justice, because it relates to Dublin. Because this judgment had really a big impact in Belgium, and it's also to show the role of this case law in national legislation. Because in Belgium, actually, and it's a judgment of 2012, when someone received an order to leave the territory because he is under Dublin procedure, that he has to go to another member state, there is no real, in general, there is no forced transfer. But according to Belgian law on reception, the reception right ends with the delay of the order to leave the territory. And what the court in Simad and Gisti said is that there is only one category of asylum seekers, and that we cannot make a difference between people who are under Dublin procedure and the others. This is the principle of non-discrimination. And the problem is that this principle of non-discrimination is really put at stake with this new proposal of the Commission. Because in this proposal, there is a new article stating that people, applicants, who are under, who do not find themselves in the member state where they are supposed to be, well, they are not entitled to material reception conditions. And this is very concerning. But saying that, on the same time, the Commission says that, nevertheless, they're entitled to a dignified standard of living. And coming to that, then, okay, for us as a reception agency, to ensure a dignified standard of living is to give material reception conditions. And we see that with all the disposition to reduce or to withdraw. How practically do you want, we can withdraw. So there are articles, there are lots of different situations where reception conditions can be reduced or withdrawn, but healthcare has to be guaranteed, but also the dignified standard of living. So when we need to transpose that in national law, the question was, okay, so there are kind of sanctions. From a political point of view, I mean, we want to apply them, we want to have them in the law, but then how do we do? Because we can only reduce daily allowances. We cannot reduce accommodation, food, clothing. So daily allowances. And the daily allowance of someone living in a collective center in Belgium is 30 euros per month. So we are going to reduce that to 15. I mean, it's very, so I mean, this kind of sanctions are in practice when material conditions, reception conditions are granted, almost impossible to implement and to apply. So that's what I wanted to underline. And also, if I may, just because, I mean, I called this intervention towards harmonization of reception conditions in Europe. Well, yes, we are going towards harmonization for the last 15 years. So there are positive steps that are taken, but yes, it will be flexible because it's impossible to fully harmonize. What would it mean to fully harmonize reception conditions in Europe? There will be always differences. But it's flexible, but not flexible as the solidarity among member states concerning the mechanism of relocation. Because the member states which stand against such mechanism of relocation will stay nevertheless bound by their obligations under the Reception Conditions Directive towards those applying for asylum in their country. And I'd like to end by saying that what ultimately matters is that a dignified standard of living is effectively available to all asylum seekers, whatever the type of reception conditions provided. Thank you.